to manslaughter is the killing of someone else by the act, procurement, or even criminal negligence, and it's not justified. So if the evidence bears out that you followed, stand your ground only applies if you are not the attacker or someone that provoked.
Right.
If he was the follower.
Let me go back to Jeantel admitting that she lied under oath. Watch this.
You also, though, told Mr. Della Rionda under oath that you'd gone to the hospital. Correct?
He had asked me, did I go to the hospital? I said, yeah.
So I know that you had said that earlier to Mr. Crump and to Ms. Fulton to give a plausible explanation to them for why you didn't go to the memorial service or the wake. Is that right?
Yes, sir.
And then when Mr. Della Rionda asked you about it again, you gave the same answer.
Yes, sir.
But you knew that was a lie.
Yes, sir.
Again, you lied because you wanted to give a plausible answer to Ms. Fulton as to why you didn't go to the wake.
Yes, sir.
But on the April 2nd interview, you were in fact under oath.
Yes, sir.
And you knew that.
Yes, sir.
And you made a decision then, because of how difficult the situation you had just been put in, you decided to lie about going to the hospital rather than say something that might be painful.
Yes, sir.
There were a series of lies.
Yeah, and the question is that an excusable lie? Now, the truth is that there's a lot of people amongst us that don't have the stomach or the heart to attend a wake, to attend a funeral and say, I can't go. And they come up with lies and excuses. In terms of lies, it's not a damnable lie. And again, there's this empathy. But it does prove that the witness is capable of telling a lie, even when she swears to tell the truth.
And that's not the only instance.
No, she actually can't keep much of her story straight. She told different stories during the investigation. She's on the stand giving different answers to the same question. And again, this all goes, we can feel sorry for her. We can. But it goes to her credibility. And if she's the star witness, supposedly having to prove that George Zimmerman was the aggressor, we can't believe what's coming out of her mouth. That's a problem.
Look, she said at one point, couldn't hear Trayvon, I could have heard Trayvon, I could. There's been, they may seem small, but cumulatively there's, 4, 5, 6 of these instances.
I am not saying she is a witness who is your dream witness. She was not, and she absolutely hurt herself, and she proved herself to lie. And she admitted those lies on the stands. What I think is important to remember, she is not testifying in a vacuum. You have lots of neighbors and lots of other pieces of evidence that if the prosecution puts it together by the end to say, look, these couple things, whether you believe her, you can accept a witness, you can disregard them, or take parts. If you take what she says, the basics that have never changed, and a lot of what she says has never, ever changed, the basics, and you put it with the other, you can still end up with criminal liability, whether it's murder or manslaughter. We're talking about heavy penalties here.
Mr. Zimmerman says that it's self-defense. And when we hear testimony that his alleged victim is engaging in this kind of language and thinking in these kind of terms, then it gives credibility to the notion of self-defense.
He was being followed in the middle of the night while he was walking home from a store.
That's the allegation.
By a cracker.
Right. That's not just the allegation.
Listen to what he just said.
By a cracker.
I don't care who's following home. Someone shouldn't have been following him home, coming home from a store, and that is on videotape. You see him buying the Skittles. You have not only the phone
All right, but let me argue against this. But there's one thing that nobody saw who punched who first. And all we know is George Zimmerman had injuries consistent with his story, a broken nose, lacerations on his head, and when he shot Trayvon Martin, Trayvon was on top of him. How do you overcome that?
I don't think it matters who punched who first, and I'll tell you why. Because
you tell me why when we come back. All right, we got to come back more with our panel, right?
No, sir, I wasn't there, sir. Yes, sir. Yes, sir. I had told you before. I did not know this man was out of jail. I don't remember saying that, sir. What?
Yeah, just earlier today.
By who?
By you.
You ain't get that from me. I called back again, sir, and I had text, sir. If he was going to confront the man, he would have told me, oh, I'm about to confront the man to see what he wants. He did not tell me that, sir. He just told me he trying to get home, sir. But the man was still following him, sir.
And we continue with Peter Johnson, Jr. and defense attorney Joanna Spilbor and also prosecutor Anna Sigga Nicolazzi. First of all, her demeanor changed from day to day. I got the impression she was coached. That was my impression. Combative. What did you think about the attitude on...
Depending upon the moment, she was able to change emotions and change stride and change mood and pitch. And so sometimes you wondered whether some of her demeanor was honest and accurate and truthful and genuine or not, because she had a capacity to be kind of sharp and actually put the defense lawyer back on his heels a little bit and kind of almost take control of the courtroom a couple of times and take it away from the defense lawyer. So that was interesting.
There were some good moments. I would agree with that, but I think overall it's the credibility issue. What do you think?
Yeah.
I thought her bad attitude also detracted from her credibility. And let's take it a step further. She's supposed to be Trayvon Martin's friend. The prosecution wants to paint Trayvon as a choir boy. Choir boys don't hang out with people who defy authority. She's rolling her eyes, calling questions, you know, retarded. She's really being defined in that courtroom. Putting the defense attorney on his heels, I'd say she was just being completely disrespectful. So, do disrespectful people hang out with other disrespectful people? If I'm on the jury and I'm laboring to hear her and figure her out, that's where my mind's going.
That goes back to the cracker comment and the N-word that she used. Yeah.
I don't think the prosecution is trying to paint him as a choir boy. They're trying to paint him as a young man who was minding his own business, coming home from buying snacks for a 12-year-old child when a man was following him because he wanted to be the one to catch this supposed
Let me ask you a question.
Shot in the chest.
Does somebody always walk not on the sidewalk but on right under the eaves of homes? I understand that, but this is where there might be confusion in the issue. In other words, a neighborhood that has had a lot of crime. Then you've got somebody that's getting out of the rain, and there is, you know, suspicion on both sides.
Let's give George Zimmerman that, okay? Because I do not think that he came in here as the worst human being in the world by a long shot. I don't. I think he was overzealous. But let's give him what you're saying. And let's say that the confrontation results from them. Let's just, for a moment, say that you believe the evidence, that he's following him, and now that he turns around, Trayvon Martin, and says, what are you following me for? He said, and then George Zimmerman says, what are you doing here? A fight ensues. Let's forget who throws the first punch, because to me...
That's important, who throws the first punch.
But as the prosecutor, I would tell that jury it isn't. Because if it's Trayvon Martin, it's only because he's fearful of this guy who's following him.
Now, here we have the injuries that are consistent with the story of George Zimmerman.
They're not.
Of course they are.
But here's the problem. Here's the problem. You're not painting a picture of justification in terms of Trayvon Martin striking Zimmerman first.
No,
just the
because
fact that
being
he's
followed. You don't need to
that
strike.
does not provide you the ability under Florida law or New York law to strike out at someone.
But let me
was he an apprehension of loss of life?
The only deadly force used here was by George Zimmerman, and I do not believe George Zimmerman believed that he was about to be
You're a great prosecutor, but you said it earlier. It doesn't matter.
Look at these injuries. Look at this.
Those injuries aren't that bad. He has an inch cut to the head, a half an inch, and he got
busted up nose,
hard.
lacerations in the back of his head.
Hardly close to death or massive
he said,
injury.
well, look, for example, I asked him who was screaming. Here's the answer. We heard the screams on the one recording from a neighbor that was calling the police, and there's been some dispute whose voice that is. Was that your voice screaming, or was that Trayvon Martin's voice screaming?
That was my voice. Absolutely.
That was your voice?
Yes, sir.
Well, that's his claim. Is anyone going to dispute that?
Let's say that it's George Zimmerman saying help. because someone's getting the better of you in a fight, you cannot take out your gun and shoot them.
No. Unless you believe that person is going to kill you.
Yes, exactly. And do you think that he really thought he was about to die?
And you've dealt with cases in the criminal realm, and I've dealt with cases in the civil realm where there's not a mark on someone's head, and they suffer a subdural hematoma.
That is not a guy who's getting his head cracked into the cement.
But he says he's being banged on the head.
And he said he said you're going to die tonight is what he said.
The crux of the case is what George Zimmerman believed. If he had a reasonable belief, it doesn't have to be that he was actually going to get harmed. He had to reasonably believe.
All right,
that
last question for all of you.
Last question. Not harmed.
With no witness, how did they get to second-degree murder, Peter? How did they get there?
If this is the only witness, they're trying to have an ear witness based on eyewitness testimony. It's difficult to do. And the testimony we heard does not help the prosecution.
What do you think?
I think the prosecution is doing a great job of proving reasonable doubt for the defense. So far, that's what we've got, reasonable doubt.
I disagree. You know, I understand why they charge. I don't know they're going to get second-degree murder, but they charged it based on the belief of the evidence that it was him on top and he pulled out his gun and shot.
We know
that
he was on top.
That would be depraved. No, I'm talking about that it would be Zimmerman on top and that he shot, and so it would be depraved.
I'll be honest. All the evidence that I see now, his injuries, that fact that Trayvon was on top of him, and no one can contradict it, I don't see how any way he should be found guilty.
Well, I see criminal liability. To what degree, I don't know, because we haven't seen all the evidence yet, but we'll see what the jury does.
All right, guys, thank you.